Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This police unit is trying to box him in, but instead he just crashes into the tree, and away he goes. But let me widen out. I don't know how far this will take him. Yeah, he's basically cornered. Wow, look at this. Off the road and onto the freeway. Oh my gosh, so he is on the freeway, going wrong side of the road here on the 91 freeway, going eastbound in the westbound lane. This car is smoking. I pray to God that the vehicles that are coming in his direction see this car coming at them and they're able to stop before we see a collision.
All right. Hello, everybody. I'm in the wrong space again. I forgot to fix it. I'm going to shrink down. I'm going to be down here. Welcome back from lunch. Welcome to the Court of Public Opinion. I am the Recovery Addict. We have a doozy of a case that's happening right now that we're just grabbing the last of. We're going to be jumping to. Let me turn that down just a little bit. I look like an 80s Sears picture. I'll take that compliment. I'll take that. You're basically saying I'm like a model. That's what I hear. An 80s model. That was my time. Man, life was good back in the 80s. I was in the single digits. as far as my age for most of it. All right, welcome. Good to have you here. All the cool kids are standing. That is true. Britta Aller, congratulations first in chat. There you are on the screen, right in my eye. Ouch, Britta, ouch. Hang on. Let's see where I can put you. That's not a problem. Where can we put Britta? Okay, right over here. Is that better? Is that a little better? All right, good times. All right, we have a few things to take care of today. Least of which is I'm in the wrong spot constantly. That's the wrong way. I need to go that way. There we go. Nope, now I can be over here. All right, this will work. Now I'm just too big. I have to be little man in the corner. You can't be big man. All right, that'll work. That'll work for now. But now you, okay, we're all good. We have a hearing that we actually saw the beginning of that we didn't get back to, and we need to jump to. Britta, by the way, congratulations. Where's your message for us? Where did it go? There it is. It's on screen. First in chat, you win the internet. Congratulations. Everything IP related is yours. I'm the little man in the corner, but I'm not in the box. I'm the man in the box guy. So welcome. Who's that? Who sings that one? It's a little bit crude, but who sings? It's a rock song. Who sings "I'm the Man in the Box"? Won't you come and save me? That one. Somebody knows it. It's not an oldie, I can tell you that. It's pretty hard. Paroled from the box. It's hard rock, like hard. Alice in Chains. There we go. Alice in Chains. That's who it is. Thank you. All right. Where we are today, we have a little hearing that we're just trying to catch the end of. I think I just got it. I hope. Not sure. We're just waiting to see if it's done because it's.
I'm not going to argue about semantics here.
It's a good one. It takes a minute to develop, but Mr. Brent White appeared in Judge Webster's court in 13th Circuit there in Kansas earlier today, and he got a little attention.
From the Walmart.
He got attention because he was quite active with his phone, walking around all over the place. And the judge was like, Mr. Brent White, sit down. You're making everybody dizzy. Hold still. You're in court type thing. Yes. we are going to go back and see see how Brent fares as his time in court is coming quite rapidly. As a matter of fact, it's here. Let's see if we can get a clean feed over to BDMI, HDMI, and send this one down there. Clean feed, got it. Make sure we have audio on. And is there anything else I'm missing? Oh, hey, stop. Calm down, Judge. Calm down. No need to get all excited. Wait. Okay, here we go. That's where we're going to start, right here. Whew. Sorry about that. Got a little crazy there with the sound. But let's give this one a go. As you guys see, we are here with Judge Webster. Mr. Brent is in the bottom right-hand corner. Brent is going to have some issues today. Oh, it's still going. It hasn't stopped. What? It's crazy. Okay. Well, we're still recording as we begin. So, Brent, let's give it a go. Let's see where we're at here.
Mr. Regier, anything further?
Nothing.
You have to.
Nothing further from the state, Your Honor.
All right, then Mr. West, look for that breakout
Mr.
room,
West is done.
and you'll see court security too. And now, Mr. White, if you'll click on that little microphone, please.
It's not working. I'm clicking. No, wrong one. You clicked on the camera.
Can you hear me?
Watch Mr. Regier.
I can't see you, Mr. White. You fight computers like I do, I think. Okay.
Mr. Regier is going to break.
Now click on the microphone.
His
video
smile.
and audio.
His smile is going to show through.
There you go.
So keep an eye on Mr. Regier in the top
Can you
left.
hear me, Mr. White?
I can hear you guys.
All right, sir. We're on the record in 2025, TR 878, State of Kansas versus Brent Lee White. Jared Regier for the state. The defendant appears in person and pro se. You are Brent White? Yes? Sir, are you Brent White?
Yeah, I'm here for Brent White.
You're not Brent White?
I am what gets called Brent White. How do I turn this camera around? I'm show you.
Well, you're looking good. You're appeared good for me. You can't see?
Okay.
All right. So
It's all right. It's okay.
all right. So you're Brent Lee White, sir? I'm not clear on that. Do you answer
That's what the driver's license says.
Driver's license says that. All right.
That's what your driver's license says. Is that what your birth certificate says?
That's what it says.
That's what it
Okay.
says.
So in count one, you are accused of operating a motor vehicle without a license, or at least a valid license, in Butler County on February 24th of 2025. This charge is a Class B misdemeanor. If convicted, you could be ordered to serve up to 6 months in the county jail, although probation's an option, and you could be ordered to pay a fine up to $1,000, although we often see a much lower amount imposed. In count two, you're accused of driving on that same date without liability insurance, and this charge is a B misdemeanor. If convicted, you could pay up to $1,000 in fines and serve an additional 6 months in the county jail. Now, this charge has a minimum fine that you must pay of at least $300, but no more than $1,000. You do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for a court appointed, or you can waive your right and represent yourself. Mr. White, how do you wish to proceed on the issue of an attorney?
Well, I would
What?
I'm sorry, you're cutting in. You're cutting in and out.
I wouldn't want to let anybody else represent me.
Okay, you're going to have a better communication signal than what I've just heard, because I didn't hear but bits and pieces of that. You seem to be moving around a lot. Where are you?
Minneapolis, Pawnee.
Minneapolis.
My phone,
and
it keeps
Pawnee.
dying. It's too hot outside. We do this. It says
Well,
that
Mr. White, we have to be able to understand each other. Where are you?
Wichita, Kansas.
Wichita, Kansas.
Wichita, Kansas?
Yes.
Hang on, I've got a scam call.
The corner of
I've got a scam call. Wait. Mr. White, you can wait for just a second. Hello?
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 Can you hear me? Hi, my name is Jennifer, and I am calling you from Incident Claim Support. How are you doing today?
Can you speak a little slower, dear?
Well, this call is regarding your car accident that happened in the last 2 years, and the compensation amount is still pending for you. Is that correct?
Can you speak just a little slower?
Sorry, I didn't understand. Could you repeat that? I am calling to talk about your last car accident in the past 2 years, and the compensation amount for innocent at the time of your accident hasn't been delivered yet. Is this correct?
Can you speak just a little slower?
Sorry, I didn't understand. Could you repeat that? I am calling to talk about your last car accident in the past 2 years, and the compensation amount for being innocent at the time of your accident hasn't been delivered yet. Is this correct?
I think so. I'm trying to get through the AI. It wouldn't let me. Sorry. Okay, we'll continue.
Pawnee and Minneapolis.
Okay.
He's at Pawnee and Minneapolis in Wichita.
Can you get to a different location where I can hear you better?
My phone is like the milk. I got it plugged in right. This is the only plug-in I got.
Well, I may have to set this case over to another day, and you may have to come to the courthouse, because I am just not hearing you. You just keep cutting in and out.
Yes.
It's just not working.
I motion to dismiss.
Motion to dismiss.
Motion to what?
Dismiss.
Dismiss.
Well, if you're going to motion to dismiss, you're going to have to do it where I can hear you and hear your argument.
I've already paid $1,500 to the BUDC. That's the BCDC. You can't read people's handwriting, but it's a Butler County cash bond. I was arrested on a bench warrant. County said the bench warrant went for court, and today is the only court date I've ever had in Butler County until then.
I do see that you posted a $1,500 cash bond on June 7th of 2025 for you to appear today, and you have. But
what was the court date before? What was the court date before?
I can't conduct hearing with this kind of in and out volume. So can you get to a better location?
There's Burger King over here.
Burger King?
Possibly better.
Yeah, let's try Burger King.
Dollar General.
Dollar General's good.
Okay, go to Dollar General and see if that'll help.
Can you still see me?
Yep.
I can still see you. Tell you what, while you're relocating, Mr. White, while you're relocating, while you are, okay, you're in the Dollar General now.
We see it. You just
I am.
Okay, I think we can hear you now. Yeah, but you're going to have to stop moving around.
Now, how do I turn this camera around so I can show you what's
You're doing fine. I can see you. I would say don't turn it around. Stand still in one place.
Okay, so the cash bond, I was arrested on a bench warrant for not showing up to court.
Okay. All right. Let's try this again. Stay in one place where you were. I heard you better. I think the deeper you go into the store, the more you lose signal. So can you go back more towards the outer door?
How about you pop a squat right
can
in
you
front
hear
of the
me right here?
talkies?
Yes, that's very good. Don't move. All right.
Sitting down in the store.
Now, we're still on the record in State of Kansas versus Brent White, 2025 TR 878. Jared Regier is still present for the state, and Mr. Brent White is now at a location where I think we can conduct this hearing properly. And Mr. White, I acknowledge that you did post a cash bond in the amount of $1,500 on June 7th, 2025, to appear here today on count 1, operating a motor vehicle without a valid license.
That's not what this says, though. I disagree. It's not what it says. It says be here August 27th.
Okay.
2025.
All right. I'm reading from your complaint and information. And I've already gone over this, but I'm not sure the way your communication was going in and out that you heard me. You are charged with driving without a license, a B misdemeanor, and driving without liability insurance, another B misdemeanor. These both have maximum penalties of $1,000 fine and 6 months in jail. The insurance does have a minimum must-order fine of $300. Sir, you have the right to an attorney. You can hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for a court-appointed attorney. You also have the right to waive attorney and represent yourself. How do you wish to proceed on the issue of an attorney?
I'd like to talk to an attorney, but I don't want anybody to represent me. But
move forward, or whatever you were doing a while ago where I heard you.
I do want to speak with a lawyer, but I don't want a lawyer. I don't want anybody to represent me but myself.
Okay. What I heard out of your garbled voice, you want an attorney, but you do not want anybody to represent you, and then I kind of lost it.
I will represent myself.
Oh, you will represent yourself. Are you an attorney, sir? Are you an attorney, sir? I'm just asking.
I'm not.
You're not? Okay. But you want to represent yourself. You do not want a trained, schooled attorney.
I would like to consult with one. See, this says it's for me to show up on August 27th.
Okay, that is a receipt.
That's the cash bond. That's the cash bond that you were talking about. It said that I was to show up here.
Your Honor, I'm sorry to interrupt, but I understand why he's confused. His summons was for today's date, and then there were orders put into his case due to an unserved summons. He was arrested and bonded out, and his bond date is for August 27th, and that's where he keeps getting that date from. So his bond is not yet in his case. I just received the money for the cash bond.
Okay.
It was paid January 7th or June 7th.
All right. Well, you were told to be here today. You are here today.
And I was told that the bench warrant was for this court hearing. I mean, this is the first time I've had court in Butler County.
The day let's see.
There was a sheriff at my house to give me the summons for this day, and a neighbor told me about it. I called the sheriff's department. I was able to get a hold of the sheriff who was at my house, who told me that court was the 16th of July. I told him, I couldn't be there by 10, but I called him. I called the sheriff's department every time I went to that house. I never had another officer come to give me the summons.
All right, April 21st, 2025, a summons was issued for you to appear July 16th, 2025. That much is correct. The problem is they could not locate you to serve you with that summons.
I called the sheriff's department every time I went to that house in Lakeland.
Hey, sir, listen. So because they could not find you, after 8 days, they returned the summons to the court. And it said, the return said the address appeared to be vacant. And
I talked to the officer. I talked to the officer on the phone. I told him that next time I was in town, I would call him. I called him. I was there like 3 or 4 times, and nobody ever showed up. I called, looked at the call log, asked the operators.
Okay.
Department. They got tired of hearing.
I cannot hear a word you're saying. It is too garbled. When you go back to where you were initially, when you first went in the store and I could hear you.
This is it right here.
You're at the front of the store?
Yes.
Well, I can hear you for a word or two, and then I lose you. Okay, so that was April 21st that the summons issued. April 29th that it came back, that the place looked empty and they couldn't find you. So let me finish, please. So then, May 28th, 2025, I did authorize an arrest warrant, and you were picked up on that, and you posted a cash bond around June 7th. Actually, the return of the service was June 9th, 2025. And you did. Who is that customers I'm hearing in the store?
That was me. I told you my phone. It's 2%. It's about to die.
All right. So anyway, you posted a $1,500 cash bond, and here we are. So let's get on to the business at hand. You have these charges. Do you said you want to waive your right to an attorney?
No, that's not what I said.
All right. Are you going to hire an attorney?
I don't have any money.
All right. Are you going to apply for court-appointed attorney?
Is a court-appointed attorney going to represent me?
That's usually
what they do. They represent defendants.
He gone.
Okay. Yeah, let's do it.
All right. Can you put your camera back on?
I don't know. I don't know how. I'm trying. I don't know how.
Do you see the red camera-looking icon with the line through it?
No, I see.
Run your finger down the side or the bottom of your screen and see if it pops up.
I see the home screen, the team chat, the docs, the calendar, more.
Missy, do you want to
tech support?
Definitely, if you have any ideas.
Britta, can you help?
What? I'm in court, man. I'm getting kicked out of the store now. I'm out of here, man.
Okay.
No, you're good. Yeah, we just have any going on stuff like that.
My phone's fixing to die. What's the next date I can do this?
Now let's continue this, but you be at the courthouse in El Dorado at the next hearing.
I can't.
You have to.
I got no way to be there.
Well, if you
Got no way to get there.
if you can't find a way, I will issue a warrant, and the officers will pick you up and bring you.
I know. And I'm not trying to do that. I'm trying to do everything I can to not have that happen. Just like when I was calling the sheriff's
Why are you
department.
talking fine? If you'll just start your camera, I can hear you fine.
I don't know how to start my camera.
Hang on, Missy. Do you have any suggestions?
Missy.
I got scheduled a meeting.
Listen, stop and listen, Missy.
I can ask him to start his camera. He started it a while ago, so I don't know why he can't start it now.
Oh, I figured it out.
All right. Okay, Mr. White.
There, can you see me?
I can see you. All right.
Okay.
You're applying for a court-appointed attorney, or you're not?
I'm applying for a court-appointed attorney.
All right. Where do you work, sir?
K15 in Pawnee, flea market.
You work at a flea market at K15?
I work downtown Wichita. I'm a street clown. I pedal a rickshaw.
Which is it? You work at a flea market?
I have more than one job. Is it
All right. Okay.
okay to have more than one job?
Slow down, listen, and then answer. You work part-time at
Look at Jay Regier.
a flea market at K15 in Pawnee. How much do you make per month doing that?
This is my second weekend. I made $23. But
quit moving, sir. If you would quit moving, I could hear you better. You get a good location and you move away from it.
All right, so far $23.
$23. All right, you have a job as a street cleaner for Wichita?
Street clown.
Oh, a street clown.
I pedal a rickshaw. Yes, I pedal a rickshaw. I advertise for local businesses, which I'm not. Ain't got no advertisements right now.
All right, so you're not making anything at that right now. What else do you do?
That's it.
All right, why did you turn your phone off? Your picture's gone again.
Because it's dying. It's dying. My phone's at 1%. I told you it's gonna die.
Miss Destiny, when can he come back? What? Don't make it that October date.
No, Your Honor. I was going to suggest the August 6th one. It's probably the last one I can put on there.
That's my daughter's birthday. That's my daughter's birthday.
August 6th, 9 a.m. You must be present at the Butler County Courthouse.
I can't be there. I can't be there. I can't make it that day.
You will, or you'll forfeit your $1,500 cash bond, Mr. White.
I'm asking, can we schedule it a different day? I can't make it.
We're moving mountains to get you a date on August 6th.
Let's just finish it right now.
Well, then make your camera work.
Your Honor.
Mr. Regier.
Your Honor, the state would respectfully have it noted on the record that given the attempt at a hearing that the court has made during today, the state does have concerns about preserving the integrity of the record.
Well, I have that concern too. Mr. White, I'm continuing this to August 6th at 9 a.m. You must be here or you will forfeit your bond and you will have
I'm asking, can we do any, can we?
I can't. I really
pick another day, October here.
No, October is too far out. We need to get this resolved.
Oh, he fixed his camera.
If you want a court-appointed attorney, contact the clerk and they can send you an application. And we can get that taken care of. It sounds like you're probably going to easily qualify. Do you have any other jobs besides street clown and flea market?
Yeah. Old Town Rickshaw and flea market, and that's it. I'm looking. I'm trying.
All right. You don't have any other sources of income?
I don't.
Who supports you generally?
Me.
On $23 a week?
I got a garden. My water comes from a well.
Okay.
I own the property I live on. That's
okay. What's the value of the property you live on?
I don't know. $100. I don't. I can't say.
All right. Are you married or single?
Married.
And does your wife work?
She's a teacher.
She's a teacher, a school teacher?
And we lost you again.
She's not working right now because school's not in session.
All right. Where does she teach? What school does she teach at? Yeah, we're just not having a good hearing. Mr. Regeer's right. So we're going to set this over to August 6th, 9 a.m. Turn in your application for court-appointed attorney, which you can get.
I'm asking for. I can't be there. I can't be there August 6th.
That is the only time I can fit it in, Mr. White, and that's the order of the court.
It's not possible. Not possible.
That's the only time I've got to do it. And I'm not going to set this over to October, which is when
I can do it on Google Meets again.
We are going to adjourn at this time.
Be like this.
Your Honor, is this in person?
It is in person. He is to be at the courthouse.
I can't be there in person. I can't be there in person. I can be there.
Communication system. This is just totally unacceptable, and you've got till August 6th to find a ride. We'll be in recess at this time.
Can we please do another day? Another day.
I wish I could. Destiny, can you do any other day? Is it because it's your daughter's birthday or because you don't have a ride? Because
I don't have a ride.
Well, you're going to have
a ride.
You're going to have a ride problem any time. But I'm
not
exhausted with this argument, sir. We're not getting anywhere. So you may go.
I'm just I can't make it there. You're just saying open it here when you can't make it. I can make it there in October.
Your Honor?
Yes.
His bond date was set for August 27th.
All right. August 27th is when you have to be here.
All right. I was already planning on that. Perfect.
All right. August 27th, 9 a.m. Be here at the courthouse. All right. You may go, sir.
Your Honor.
Yes, sir.
I have a Johnny Bosley here at the courthouse. He got here at 11:40.
All right.
He won.
Johnny.
He won. He didn't. Now he can't turn his phone off. He's like, I shouldn't be here. My paper says the 27th, and they're like, no, that's wrong. He got the 27th. Nothing happened today. He won. He has to be there in person though, and hopefully that'll fix the issue. His shirt says "Big Fish." It does. Watch out, the laws behind me. Yes, they were. That's why I moved. How's everybody doing? Hope you had a great lunch. Welcome back. Let's see. We have. I'm trying to see what she's doing.
892, State of Kansas versus Benjamin Jordan Taylor, who was summoned to be here today on one count of driving while suspended after a prior conviction.
What's Denise doing? Is this a ceiling we're looking at or a wall?
And
texture is unique.
the summons was served May 1st, 2025, by leaving a copy with Kevin Taylor, a person of suitable age and discretion.
Suitable age and discretion. Always nice to have one of them around. Otherwise known as
I will issue a bench warrant recommendation on bond.
Yes, Your Honor. As a preliminary matter, is the court prepared to find legal servants pursuant to the apparent residential service as indicated on the return of service of the summons?
I do so find.
Thank you, Your Honor. In that case, the state is recommending a bench warrant in the amount of $2,500 cash or surety based off of the level of the charge currently before the court.
That will be the order. Bench warrant, bond set at $2,500.
And is that cash or surety, Your Honor?
Cash or surety.
Thank you, Your Honor.
And Your Honor, just as a note from the clerk, there was a Ben Taylor on earlier, but has not since appeared for at least an hour or two.
Okay. Well, be sure and note that in the docket, as I'm sure you have. We'll now be on the record in 2023 TR 2481. No, let's go back on the record in Taylor 2025 TR 892, State of Kansas versus Benjamin Jordan Taylor. I'm going to maintain the bench warrant, but I'm going to make that a $2,500 OR bond. Since he was here. Yes.
If the court is modifying its previous orders, my office is prepared to prepare file paperwork to that effect.
Thank you. I appreciate that. Okay, now we will be on the record in Torres 2023 TR 2481. State of Kansas versus Ineda Samano Torres. Jared Regier for the state. Defendant fails to appear on driving without a license and driving without headlamps. And this defendant posted a cash bond.
Surrenders it. He loses his bond.
In the amount of $2,000 on May 16th,
Zinger.
2025. I'm going to issue a bond forfeiture, a bench warrant, and no bond hold.
Lost $2,000 like that for not showing up to court. Ricky C. gifted a membership, or gifted 5 memberships. Thank you very much, Ricky. We're trying to jump to Judge Shackelford's court, and then we'll see if we can pick up this other sentencing hearing. Let's see. We need 23rd District Court, Judge Victoria L. Shackelford. It is L, isn't it? There it is. That's the one. Give me a second to back up just a wee bit to where we need to be. You said it was 3 hours. I'm trying to see what the message was, Josh. Hang on. 3 hours, 16 minutes in. So that's 6 hours and 10 minutes. That would put 3 hours and 26 minutes. Oh, math is backwards. Let's see if we can find this guy. Go back 3 hours, 16 minutes. I'm looking, Josh. I think that's him.
The matter for jury trial.
Yeah, this is it. I think this is one. This is the one. Can you all see and hear? Yes? Okay.
All right, we're coming back up. This is 2509380M, the City of Taylor versus Randall Crane. Mr. Crane, you want to come back up? Mr. Crane, did you have a chance to go over your constitutional rights that I provided to you?
Yes, I understand my constitutional rights.
Okay, thank you, sir. So at this time, I gave you 4 options. Would you like to retain your own attorney? Would you like to speak with House counsel and have an appointed attorney? Would you like to meet directly with the prosecutor? Or would you like to set the matter for jury trial?
I'm going to be requesting for an order of change of venue.
Denied. Anything else?
Change of venue, denied.
There's no basis for that, sir. So I'm asking you, we'll just set it for a jury trial, okay?
I have to understand everything in regards to my case.
Sir, I gave you your constitutional rights so that you could review them. I also gave you the attorney, court-appointed attorney to go over those rights with. So I gave you an opportunity to understand your rights. I'm not going to entertain, listen, I'm not entertaining your sovereign citizen arguments because they're unfounded and they're not legal. There's no legal basis for them. So I'm not doing it. So now I'm asking you, out of the 4 choices I gave you, which one would you like to do?
I am required to understand everything in regards to my case, including subject jurisdiction matters.
All right, well, you could do your research. I'm setting this for a jury trial. We'll see you back for your jury trial on November 14th of 2025 at 9:00 a.m. I really recommend you retain an attorney prior to that date, sir, because I know I'm going to tell you what you're not going to do: waste the citizens of Taylor's time with your nonsensical arguments. You're going to come in, you're going to try your case. Again, if you want to talk to House Counsel, you can do so. All right.
I'm not wasting the city of Taylor's time.
Okay, good. We'll see you on your trial date. Have a good day.
Okay, so he appeared before this, and I missed it. Let me see if we can back up a little bit and see where he was. I think he was right there. That's him. Let's get the first take.
2509380M, the people versus Randall Crane. We ready on Randall Crane? Mr. Crane's coming up.
Did I just rewind to the beginning, or? Playing the same thing again.
Hey, you, Mr. Kazicki?
No.
Mr. Crane, do you have counsel? Was that you, Mr. Barron?
Your Honor, Todd Barrett. I did speak with Mr. Crane prior to the court calling the case today. I think that at this time, Mr. Crane's probably best served proceeding on his own. There are some constitutional arguments that he's raising that I don't think, as a member of the bar, I can.
Oh, is he a sovereign citizen?
He's making some sovereign arguments, yes.
Okay, I have very little patience for them. I will let you know that, sir. So, okay, tell me your name.
My name is Randall Crane. As a living man.
As a living
Not
man.
a corporate fiction.
So you're a real person named Randall Crane.
I'm a real person. Okay.
Okay, no, listen to me. Sir, you're here today because you have some charges against you. All right.
I'm challenging the court's jurisdiction.
Okay, well, denied. Your motion's denied. I have jurisdiction to the Constitution of the state of Michigan. What's your next? I'm not arguing with you, sir. I have jurisdiction. So
you have to provide subject matter jurisdiction as well as personal jurisdiction to me before these can proceed.
Okay, your motion's denied. I have jurisdiction under the Constitution of the state of Michigan. What else? What else?
You do not have jurisdiction over the national.
I just said I did.
No, you don't.
All right. All right. So, sir, do you want to proceed on these cases and talk to the prosecutor? Don't look on your phone while you're talking to me. If you
my notes are on.
No, you listen to me. If you don't know your sovereign citizen arguments well enough to come up here and say them, I can tell you can't have a phone in here. I want you to listen to me. You're here today on misdemeanor charges. No talking. You're brought into court. You've already been arraigned. You have a charge of interfering with police officers in while they're doing official business. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating using a mobile electronic device, first offense while operating a motor vehicle. A charge of no proof of insurance. Those are both civil infractions. Civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense for an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. You have a right to, this is how trials work. You have a right to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. Lastly, you have a right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. If you enter a plea, obviously you'd be waiving those rights. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pretrial. You have a few options, sir, under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can have a pretrial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial, okay? Those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney on this green earth is going to come in and make the frivolous arguments you're making on your behalf. Or you can speak to the prosecutor, or we can just set it for a jury trial. Out of those, I don't want to hear it. I want you to pick out of those four options what you want to do. Hire an attorney, speak with court-appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question, and I'm telling you to answer it.
And I have the right to understand my rights and understanding.
Sir,
exactly
here, can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your case back up.
I am asking for you.
Have a seat right now and read your rights.
Office.
Have a seat.
Have a seat right now and read your rights, sir. If you don't understand them, read them.
I move for this court to dismiss.
Have a seat.
Okay, next case. This is 2514260T, the People versus Diana Buchanan.
Diana's not pleased.
Good morning, Your Honor. James.
I'm going to mute her for just a minute. Yeah, that's how it started, and we watched the second part first. But have a seat. Wow. Is Judge Mom mad? Yeah, she's is Judge Mad Mom. Yes, both would be true. She's not taking this behavior. She says she has no patience for it. Zero. It's like, not going to do it. Don't come in there spitting that crap, and no lawyer on this green earth is going to do it for you. All right. See if we can go jump over here really quickly. We have a little a thing happening. Let's see if I can fix this. If I disappear, and then I do this, key on still, cut, and now letter 1 with key on. Nope, we go to still with key on. Boom, courtroom's back. Fixed it. Whew, I fixed it. All right, with that, let's see if we can listen in on this. This is a sentencing hearing for a Mr. Shelby Nealy. Now, Shelby Nealy pled guilty to murdering his in-laws and his wife. but there's a hearing that should take a couple weeks, actually, that they're going to go over all the evidence. We're going to get to hear just a wee bit about that here in just a second. Let's see. If I can figure out how to make it work. Where does it start? Right there. All right, looks like we're in 6th Judicial Circuit of Pinellas County, Florida. Florida. Starting his senior year at his autism high school, wants to get certified for drones. That is awesome. Drama Llama Mama, that's a lot of fun. Drones are really cool to fly. I love them. I have a very cheap one, but I like it. Want more of that last judge. Where is she at? That would be Victoria Shackelford. She is out of the 23rd District Court. Let me see what state she's in. I don't know where. Is she out of Michigan? She's a Michigander. Okay, on the right there, the defendant wearing the white collar, or the sweater over the white shirt with the white collar, bald head. He's the defendant who pled guilty. That is Mr. Shelby Nealy. And what is happening now is, now that he's pled guilty, there is a sentencing phase. The sentencing phase appears a lot like a trial phase, although the only thing to decide
another judge is going to do my calendar.
Is the sentence.
And then and we're going to hear from probably 4 witnesses today. The 4th one is going to be on Zoom. So we're going to take a break between the 3rd one and the 4th one to make sure we have Zoom ready, okay? And I don't think there's anything else that we went over. Is there anything else that Mr. Nealy needs to know? All right. Again, we are going to hand out the preliminary instructions so that they can read along while I'm reading them, and then I'll collect them. Then I'll or
I think this goes for about 2.
Give them their notepads.
Could be 2 weeks.
I'll go over
2 days, 2 weeks.
Note taking from the standard jury instructions. Okay, and then we'll start with openings right after that. Okay.
The bailiff is right on him.
All right, so are we ready for the jury?
It's a fancy computer cover.
Anyone who is not ready for the jury? Okay, so let's bring the jurors in.
Bring the jury.
If you will bring the jury.
There we go. Little Judge Newman.
Swear him in normally. That's all. The swear him in. That makes it normal.
Oldie but goodie. Yes, this just started today, right about lunchtime. So this is fresh. No trial in this one. There was no televised trial because he pled guilty. So I will warn you that that this is a gruesome murder case. All right. There's a jury for the sentencing. Just for the sentencing portion in Florida, yes. Now, in Florida, now, hear me out. I believe in Florida the death penalty is on the table for this. And that Florida does not require a unanimous jury decision to reach a death penalty. Now, they do require the unanimous to get the guilty verdict, but on the sentencing, it's not unanimous. That's my understanding here. So we might dig into that a little deeper as we progress through this. I saw Runkle was traveling around in the U.S. and meeting people and everything, and there were discussions as to his height. So that's awesome. I have not yet met him in person, but Runkle's amazing. One of the good ones. He also did kill the pets, the parents, the pets, and the wife, all killed. After he killed his wife, he was continuing to contact the parents using her phone, pretending to be her, and sending pictures of, I believe, their daughter. They got suspicious based on some of the replies and decided to come visit in person, and that's when they were killed as well. So, pled guilty to 3 counts of first-degree murder, 3 counts of aggravated animal cruelty. Do we know why? Well, we're going to hear why.
All right. Members of the jury, welcome back. What's going to happen at this point is I'm going to read the preliminary instructions to you. And I'm pretty sure I told this to the Monday people, but maybe I didn't say it yesterday, is that I'm going to give everyone a copy of those preliminary instructions. And I think most people process information better by reading along while I read them. Then I will collect them, or the bailiff will collect them after I read them. If you're the kind of person who processes information better just by listening, that's fine. I think most people process information better if they can read along while I am reading. Okay? And then we'll collect them. Then I'll go over note taking. We'll give you some notepads to take notes if you want to, and I'll go over that instruction. Then we'll have opening statements. The plan, as you know, plans can change, is to put on 4 fairly quick witnesses today. At the end of the third one, we're going to have to take a break to set up a Zoom, because the fourth one's going to be on Zoom, and then we'll end for the day. All right, everybody good with that? All right. All right, go ahead and hand them out.
The courtroom looks very similar to the one that Mr. Robert Tellis was tried in Las Vegas, with that same style of marble background. It's a frequently replicated courtroom design, even down to the light-colored wood, with the seal in the center, the judge positioning. It's just I guess it's a drag and drop design.
All right, everybody has one? Very good. Members of the jury, the defendant entered a plea of guilty to 3 counts of first-degree murder in this case. The only issue before you is to determine the appropriate penalty. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence is presented for you to determine whether the state proved, beyond a reasonable doubt, the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of the crime or the harm to the victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor has been proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision.
kind of
The
pencil
aggravating
case is that?
factors alleged by the state in this case are, number one, Shelby Nealy was previously or contemporaneously convicted of another capital felony or a felony involving the use of violence to another person.
What is that scratch?
The crime of murder in the first degree is a capital felony. The crime of manslaughter is a felony involving the use of violence to another person. Number two, the first degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Number three, the first degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil.
Always
Atrocious
heard of it.
means outrageously wicked and vile.
Heinous.
Cruel means designed to inflict a high degree of pain with utter indifference to, or even enjoyment of, the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Laura Ivanchik, Nicholas Ivanchik, and Richard Ivanchik. And number four, the first degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, although insufficient to reduce the degree of the murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Once the state has presented evidence of the existence of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate that the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, you will begin your deliberations. You should not form any definite or fixed opinion until you have heard all the evidence, the argument of the lawyers, and my instructions on the law. Until that time, you should not discuss the case among yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you're on the jury and ask the person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off.
This camera's
At the end of the
crooked.
case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or inappropriate sentence, and the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary. All right, so if Deputy Trong can collect the preliminary instructions, I'll...
We're going to begin with opening statements here in just a second. So basically, we're arguing between life in prison or death penalty.
All right, now if we can hand out the notepads. We're keeping Deputy Trong busy.
We've seen the judge briefly, I think, but it's a tough decision. I don't know of any jury that takes deciding a death penalty case lightly. Ashley, I don't remember what I had for lunch. I'll need some memory reminders as to what that case was.
As I said on Monday, and I don't think I said on Tuesday, obviously at the very close of the case, I'm going to instruct you on the law. You'll also have a copy of those final instructions.
Murder times 4 or 5, something like that.
Follow along as I read them. And you'll also be able to take them back into the jury room with you. So you'll have a copy of those. You'll also have all evidence introduced in the case as well. All right.
The judge is behind this computer monitor, just underneath the American
flag. What I'd like you to do
flag.
at this point is to write your name nice and big on the very first page. And then if you are going to take notes, start on page 2.
This just began at lunchtime.
We can see that it's your notepad, it's not anybody else's. And then no one will read your notes.
Don't
because the
steal
purpose of this
notepad.
is for you to refresh your recollection if you want to take notes. It's not for other people to read your notes.
Some of those Harrods pencil cases can be quite expensive. I think even the
Everybody
cheapest
ready?
one's like $16.
If you would like to take notes during the proceeding, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and a pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, just put your notepad down on your chair. If you want to take the pen with you, you can. Just don't forget to bring it back.
I've been to London, been to Harrods in London.
The bailiff will deliver your notes to me. I will give them to my judicial assistant. She will destroy them. That's one of her favorite jobs, especially compared to the other things that I give her. No one will ever read your notes. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. All right, anyone have any questions before we begin with opening statements? All right, I'm going to see any hands. Ms. Raby, you may proceed with your opening statement.
Mr. You forgot the name. Prosecution opening statement. This is the first time a jury has heard any of this evidence because he pled guilty. It was not a jury trial.
3 weeks. We are here today because between December 14, 2018 and December 16, 2018, this defendant, Shelby Nealy, murdered Richard Ivancic, Laura Ivancic, and Nicholas Ivancic so that he could avoid the consequences of his actions for what amounted to 3 more weeks. Thank you all for your time and attention thus far. I know it's been a long day, a long process, but opening statement is my opportunity to tell you what I expect the evidence to show. A summary of the story that is going to come, if you will. And the testimony and the evidence in this case is going to transport you outside of this courtroom and into the lives of, and the last days of Richard Ivancic, Laura Ivancic, and Nick Ivancic. The day before, or 2 days before, he was brutally murdered was Richard Ivancic's 71st birthday. You'll get to hear a little bit about Richard. He was an athlete in high school, married his high school sweetheart, and with her had 4 children: Richard, same name, Renee, Mike, and Mark. They lived in Ohio, and after a number of years, Richard and his first wife separated. Get to the mid-1980s, Richard would eventually meet and marry Laura Ivancic. Laura was 59 in December of 2018 when this defendant brutally murdered her. Laura and Richard had a passion for fostering children who didn't have any other place to go, who needed love and care, if only for a little while. Nicholas and Jamie were the 2 children that, after fostering, they were able to adopt, not providing just a temporary refuge and temporary love and care. Instead, Richard and Laura were there to provide them with permanent love and care. Nicholas had been born in 1993, which means he was 25 years old when this defendant killed him. And Jamie had been born in 1997. So in Ohio, where all these people were living for a period of time, Nick, as he got older, teenage years, worked for a time at Burger King. And he becomes friends at Burger King with another employee there, this defendant.
Not a sponsor.
Through this friendship, the defendant meets Nick's sister, Jamie. They become romantic, the defendant and Jamie, and they marry. Early on in their relationship, which would have been roughly 2015 and 2016, they moved to South Florida, where Richard had moved, and lived with him for a time. But then they end up moving back to Ohio, where Laura had remained and was living because her mother was dying and she was staying to care for her mother. This defendant and Jamie have a child up in Ohio named a little girl named Bella, who would have been roughly 3 in December of 2018, when the most relevant time period. So the defendant and Jamie live with Laura or other members of Laura's family for a little while up in Ohio. And then the defendant and Jamie end up moving back down to Florida and living again with Richard in Spring Hill, here, close to here in Hernando County. Jamie and the defendant and their child live there for a time in Hernando. Laura's mother does pass, and she moves down to Florida to be with Richard. So roughly mid to late 2017, this defendant and Jamie rent a house at 10930 Norwood Avenue in Port Richey, which is in Pasco County. So now they and their child are living there alone, and Jamie has a second child, a little boy who will end up being approximately 1 year old in December of 2018. By mid to late February of 2018, the residence at 10930 Norwood Avenue is abandoned. Family is gone. Jamie's phone's having problems, but Laura and Richard and others still communicate with Jamie via texting or social media. Time passes. Laura and Richard, who had been close with Jamie, living with her, regular part of her life, they keep communicating with her, or trying to communicate with her, and trying to see their daughter. Jamie's family is in Ohio, and they're in Texas. Finally, Jamie and her family, which would be this defendant and the 2 kids, are going to come to Florida to visit. So by now, Richard and Laura have moved to 1954 Juanita Way, which would have been, they moved there sometime in mid-2018, which is in the Little Mobile Home Park in the northernmost part of Tarpon Springs, here in Pinellas County. It's a 55-plus community, but Nick stays with them for the most part too. He lives there as well. and he had been living with Richard for some time in Florida at the point where Richard had moved down here. So now Jamie and her family are coming to visit 1954 Juanita Way early to mid-December of 2018. They'll be there for Richard's birthday, the holidays, but at some point between December 2nd and December of 2018 and December 7th, so 2nd and 7th of 2018, Jamie's gray Hyundai vehicle arrives with this defendant, the two kids, but no Jamie. This defendant explains to them how Jamie couldn't make it because of work. She had to stay in Texas. They were also ducking collections investigators because they had abandoned the Norwood Avenue residence. So Jamie remained in Texas and didn't come. So the defendant and his two kids, remember about 3 and about 1, are staying with Richard, Laura, and Nick for at least a week, which brings us to December 14th of 2018. So we know on December 14th that Laura goes on a shopping trip. We know it takes her up to State Road 50 in Hernando County. She goes to a CVS, she goes to a Cracker Barrel, she goes to a bank, and then the last place that we know she goes is to a Walgreens on US 19 in Port Richey, which would be on the way back. And that's at 3:45 p.m. in her red 2013 Kia vehicle. So backing up just a bit, the day before, which would be December 13th of 2018, was Richard Ivancic's birthday. Richard, as I mentioned earlier, turned 71. And on that day, he spoke to people on the phone. In particular, his son, Richard, I'm going to call him Rich to distinguish, his son Rich. And that is the last time that anyone outside of the people staying at 1954 Juanita Way will hear from Richard. Because once you hear the evidence and put the pieces together, it will show that Laura goes on that shopping trip. And either during those hours shopping, as the evidence will suggest, or potentially, maybe on the 15th at a shopping, if she's shopping again, definitely no later than the 15th, that Nick is apparently not home as well, possibly working. So Richard is alone, 1954 Juanita Way, with this defendant and the two small children. And this defendant, all along, had been planning to murder everyone in that house. So while Richard is walking in the house, in the dining room area, towards the kitchen, this defendant, armed with a hammer, attacks him. Richard gets hit twice in the chest. A third blow hits him in the neck. And then he is struck multiple times in the head. Richard lies there horribly injured for some period of time as the defendant realizes he's not dead, and then comes back and attacks him more, inflicting injuries that will ultimately result in Richard's death. Richard gets hit in the head at least 7 times that can be detected. Because multiple blows are hard to tell. If you're hitting somebody in the same place over and over again, you can't necessarily distinguish it as multiple blows. But there's at least 7 blows to the head. In the nose, in the forehead, in the right eye, in the back of the head. So the defendant leaves Richard there on the floor and waits. He waits for Laura to return, so that he can bash Laura's skull in as well. So Laura, as I told you before, we know was at Walgreens in Port Richey at 3:45 p.m. on December 14th, which was a Friday. Given travel time, she's alive until at least 4 p.m. on the 14th. Give or take a few minutes. So she walks into her house, no idea that Richard is lying with his head bashed in, dying on the floor. And as she goes to enter the kitchen, the defendant begins bashing her head in with a hammer, striking her at least 5 times in the back of the head. So that leaves Nick. While Nick is away, the defendant begins to hide the evidence of his horrible crimes. Both Laura and Richard are apparently incapacitated on or very near to carpets lying on the floor in the respective rooms that they are in. So the defendant uses the carpet to roll up Laura, drag her down the hallway of this mobile home to the end door, which is the master bedroom, and into the connected master bathroom. He then rolls up Richard in the carpet, drags him down the hall into the master bedroom, and closes the door. He then mops up the floor to ensure that Nick will not suspect the violent fate that his parents have suffered and the violent fate that this defendant has in store for Nick himself. Nick will eventually return home. It is not entirely clear when, sometime between the late afternoon, early evening of December 14th, possibly sometime on December 15th. But remember, Nick was a friend, a good friend of the defendant. They were close. They are close. So the defendant wants to hang out with Nick one last time before he bashes his head in with a hammer. They get pizza. They hang out. They watch TV. They smoke. Nick even leaves to get more marijuana at some point and comes back. At some point, they watch The Grinch. This goes on. At some point between the early morning of December 15th and the early morning of December 16th, Nick is asleep on the couch in the living room, and this defendant is awake. So now it's time to finish what he traveled from Texas to do. The defendant gets the same hammer, comes up to Nick while he's sleeping, and begins bashing him in the head. Nick springs up and is not quick, like the defendant will later claim he wanted it to be, and there are multiple blows, bashing Nick's forehead in, causing the injuries that will ultimately lead to his death. At least 3, but in the estimate of this defendant, at least 5 to 7 blows. Nick is similarly dragged from the living room on some type of blanket from the couch into his bedroom and left unceremoniously on the floor just inside the door. About 2.5 weeks pass. Christmas comes and goes. Laura's brother-in-law passes away. Richard, Laura, and Nick aren't discovered dead and rotting at 1954 Juanita Way until New Year's Day of 2019. Multiple family members had tried to contact them between December 14th of 2018 and New Year's of 2019. But as they later found out, this defendant had been answering some texts on Laura's phone as part of his plan in order to throw everybody off, which we did successfully for a time. But on January 1st of 2019, Richard's oldest son, Rich, has been trying to reach his father and has not been able to. He compares notes with other family members, and he's concerned, so he calls law enforcement to do a welfare check so that the law enforcement here can have contact and make sure the people at 1954 Juanita Way are okay. The people were not okay. So Officer Rondos with Tarpon Springs Police Department responds along with other law enforcement officers. It doesn't take long to suspect that this is not the typical welfare check call they get, and that something far more sinister is going on. And it will take more than just a knock on the front door and making contact. So upon arrival, they get there. There's an obvious hole dug in the front yard. It looks like a grave. Dirt piled up on one side. Walking around the mobile home, there are flies visible on the windows, on the inside. And there's the smell. Law enforcement knocks on the door. No one answers. Front door is locked. But there's a sliding glass door that they're able to enter through a porch. And as they enter, it is more and more clear that this is going to be bad. There's a couch just inside the sliding glass door with blood all over it. And the place is just trashed. Garbage all over the floor in the kitchen. Moving into the living room from the kitchen, there's a drop cloth strangely laid out on the floor. And again, trash is lying around. So law enforcement, while announcing themselves, go deeper into the residence, into the hallway that all the bedrooms are off of. They check the first bedroom on the right. A little unkempt, but otherwise normal. Before even opening the next door on the right, they can see, which would be Nick's bedroom, they can see the fluid pooling at the bottom of the doorway. Open the door, and there's Nick, covered with a tarp. Also, paint poured on parts of him. The room is just a disaster. Paint spattered on the walls, egg on the walls, garbage just piled on the bed in the middle, trashed. Down to the next bedroom, the last room on the hall, the master bedroom. Door opens, and there's Richard, partially rolled up in a rug, covered in paint, as if someone had just poured some paint on him, onto his face. Beyond him, into the master bathroom, is Laura, kind of rolled up in a carpet, a red towel on top of her back, some paint poured on her, and the rooms are just ransacked, trashed. Paint flung around on the walls, stuff piled on the bed, just like in Nick's room, drawers emptied, completely trashed. And all three occupants long dead. So now the investigation begins. A search warrant is obtained to search the residence. Initially, at first check, the identities of the bodies were not obvious, especially Nick. And with the investigation, especially one of this magnitude, a lot begins to happen at once. The medical examiner is going to have to come, collect the bodies, to do the autopsies, figure out what it was that killed these people. The scene is going to have to be searched and processed for evidence to try and figure out what happened to these people, who may have done this to these people. Anyone who could have or could lead to information, law enforcement is going to try and seek out and speak to. So on the scene, various areas of blood spatter are found and documented. Interestingly, several areas of blood spatter on the walls have been painted over with white spray paint. But multiple receipts and similar items are found from the December 14th of 2018 and later. Domino's pizza boxes, McDonald's receipts, notably a receipt from GameStop dated December 16th and a receipt from Home Depot dated December 18th. A white Krylon spray paint can is found in a box of trash on the porch. And in the washer of the laundry room is found a shirt with the Punisher logo on it and some shorts that appear to have either paint splatter or some sort of chemical like bleach or something splatter on them. Fingerprints are attempted from all kinds of different objects, all kinds of different places within this residence. Ultimately, a hammer is located underneath the master bedroom bed. That hammer will eventually be tested for DNA, and it will match its last victim, Nick. This defendant's fingerprints end up being found all over the place. Jewelry box in the master bedroom, on that Krylon white spray paint can, on a package for masks. I say masks, I'm going to call them COVID masks. But remember, back in December 2018, nobody had heard of COVID. Nobody had even heard of a COVID mask. We all learned about that in 2020. But those things were still sold, still available, and there was a package for them.
Medical mask back then.
With this defendant's fingerprint on it. There are also some things that should be there that were not. Most notably, Laura's red 2013 Kia vehicle is nowhere to be found. The only vehicle there is Richard's, a van belonging to Richard that was really Nick's, that Nick would use. Nick and Richard's IDs are not located. There's some personal items that are missing that are expected to be there. Richard was a coin collector. There's no, all the coin collection's gone. There's a revolver that should be there that's gone. Now, I told you multiple things are going on at the same time. One of the things that develops is that Jamie and this defendant are two people that law enforcement want to get in touch with, if for no other reason than for notification of what has happened and basic information. Eventually that shifts to wanting to locate the two of them and their kids because no one is sure exactly where they are or where they even should be. Later in the investigation, Jamie's gray Hyundai vehicle is located at the clubhouse parking lot of the mobile home park, which is roughly a couple hundred yards away from 1954 Juanita Way. The trunk is stuffed with multiple trash bags full of things that clearly came from 1954 Juanita Way. Paperwork that would have been in Richard and Laura's bedroom. Laura's and Jamie's passports. Some receipts indicating that the defendant had been in Texas until at least December 2nd of 2018. In the garbage bag, some receipts from Laura's probably last shopping trip on December 14th. There's a pillow saturated in blood. And also Laura's purse, which we know had gone on that December 14th shopping trip with her. And that also has blood on it. So major focus swiftly becomes finding this defendant, finding Laura's red 2013 Kia vehicle. With the help of law enforcement in Ohio, on January 3rd, 2019, Laura's 2013 red Kia vehicle is discovered at 1573 Newman Avenue in Lakewood, Ohio. And one of the people staying at that address at that time was this defendant. So Detective Anderson and Detective Scarpati with Tarpon Springs Police Department travel to Ohio. The 2013 red Kia is eventually searched, and more receipts are found. Walmart, McDonald's, and more, spanning dates since December 16th of 2018. 1573 Newman Avenue is searched, and a wallet with Richard and Nick's driver's license is located. Also, their credit cards, Richard's coin collection is found, some other items of interest, and also notably a weight belt. Through all the receipts that are collected from the various places that they were found, detectives are able to see that on December 16th of 2018, this defendant went to Walmart in Palm Harbor wearing the shirt with that Punisher logo that was found in the washer. And he buys a bunch of scented things which were also found in the house. He goes to McDonald's that day, gets chicken nuggets at lunchtime. He goes and sells a bunch of Nick's video games wearing this same Punisher shirt at GameStop in Palm Harbor in the evening hours. And then he eats at dinner time at McDonald's, again, getting chicken McNuggets.
It's consistent.
On December 17th of 2018, in the evening, He's at McDonald's again getting chicken McNuggets. December 18th of 2018, the defendant spends the late morning hours going to Walmart in Port Richey, where he purchases that Krylon white spray paint, as well as the COVID masks. Also, some additional items to include clothes that he will later be seen in. He goes to McDonald's that day around lunchtime and gets, surprise, chicken nuggets. And then he goes to Home Depot in Port Richey. At Home Depot, he buys tarps, which are found in the residence. One of them laid out. One of them appears to be on Nick. He buys a paint can opener, which is found in the residence.
Aren't those free?
And also on the Home Depot surveillance, you can observe that he is wearing blue shoes, and I'm going to call them unblemished blue shoes. On December 20th of 2018, he goes to Dunkin' Donuts and Holiday. On December 21st, 2018, around lunchtime, he gets chicken nuggets from McDonald's in Port Richey. He then goes to Walmart in Hudson, where notably those blue shoes that were unblemished a couple days earlier now can be seen with paint or bleach splotches on them, consistent with the paint and the chemicals that were poured on the bodies. The defendant orders Domino's Pizza that evening at 1954 Juanita Way, so that would be the 21st, where he is still staying. On December 22nd, he goes to the McDonald's in Port Richey in the evening. And then on December 23rd of 2018, guess what he got there? He leaves 1954 Juanita Way for good. And he leaves, and we track him out of town. He stops at a McDonald's on State Route 54 in Pasco County in Newport Richey at about 2:30 p.m. And then we next pick him up in Macon, Georgia at a McDonald's in the evening hours on his way to Ohio.
Eating chicken nuggets.
And every time we were able to see the defendant and see the vehicle that he is using at any of those locations, it is the defendant driving that 2013 red Kia vehicle. Laura's 2013 red Kia vehicle.
So the correlation between
and then sometime Christmas Eve or Christmas, the defendant is in Ohio until he is caught on January 3rd. Defendant has, detectives get different records, different communications the defendant makes, and they reveal some of his activities, what he was planning to do as all this is playing out. As I told you, Ohio authorities picked up the defendant, and Detective Anderson and Detective Scarpati flew up to Ohio as quickly as they could. Detective Anderson ends up sitting down with this defendant, and the defendant confesses. Chillingly, heartlessly, methodically, he describes his version of what he did and to some degree why he did it. One thing he says, though, that no one knew yet, although some had been starting to suspect and likely would have been discovered soon after, is about Jamie. Remember the defendant's wife, Jamie Ivancic, who he lived with at 10930 Norwood Avenue in Port Richey. Way back in January, February of 2018, well, it turns out that Jamie never moved away from Norwood Avenue. The defendant had killed her. According to the defendant, during an argument that turned violent, Jamie had armed herself with a knife. The defendant had disarmed her and then strangled her. And while she was helpless, he bashed her head in with a hammer. At least 12 separate blows, caving in both sides of her head. The defendant had then left her body in the bathtub for a few days while he figured out what to do. In that residence, he had a fenced-in backyard, so some privacy. He dug a hole about 3 feet deep, put Jamie in trash bags, and buried her in that backyard. He then trashed that residence to distract from his crime, pouring paint or other liquids all around the bathroom where her body had been bleeding out, messed the place up, and he and his kids abandoned it. Fleeing first to Ohio and then later to Texas. And since then, the property manager had renovated the residence, rented it out again, and no one had yet thought to excavate the backyard looking for Jamie, who was, as of yet, no one had realized was missing.
Whoa. Somebody moved in, had no idea.
Because the defendant had then pretended to be Jamie on her phone, texting people, responding to texts, hiding the fact that Jamie was dead and buried in a backyard in Port Richey. It was a plan that was to some degree successful. That continued to be successful until January of 2019. But Jamie's parents had wanted to see her. They wanted to talk to her. They kept trying to communicate with her. And the defendant was afraid that his crime would be discovered. So he decided that he was going to travel from Texas to Tarpon Springs and kill them. He planned to kill them, to take their stuff, and to do the same thing with them that he had apparently succeeded with Jamie. So when he arrives at 1954 Juanita Way, without Jamie, it had nothing to do with Jamie having been at work or creditors trying to reach them. It was because she had been dead and buried for 10 months. He arrived to execute his plan that would help him avoid arrest and avoid the consequences of his actions. And execute it he did. I expect the evidence to show that days before starting his Tarpon Springs murder spree, he was planning on taking Laura's car and going back to Ohio. He waited until he could safely crush their skulls with a hammer, one at a time, when he's alone with Richard. I say alone because the two children were very small, but while he was alone with Richard on December 14th,
the children were there,
latest December 15th, he bashes his head in. He describes how he had to go back over and finish the job because initially he thought Richard was dead, but turned out he wasn't. Defendant patiently waits for Laura to return and then bashes her head in with a hammer. He then moves their bodies to the master bathroom, cleans so that Nick won't realize that his parents are both dead in that trailer when he arrives. And of course, the defendant likes Nick. Nick's his friend. Doesn't like him enough not to violently murder him, but likes him enough to hang out with him for probably maybe the entirety of December 15th. And then when Nick is asleep, he swings the hammer at him. Again, Nick was jolted awake, and in the defendant's words, I think the defendant's words are jolted awake. But the defendant is unrelenting, continues to bash Nick's head in for another 6 or 7 times by his own count, until Nick is sufficiently incapacitated, and then he drags Nick's body into the bedroom. So then there's phase 2 of the plan. Remember, bashing Jamie's head in with a hammer and burying her in the yard, trashing the place, worked so well the last time. So the defendant begins the process of burying the bodies in the yard at 1954 Juanita Way and of messing up the crime scene. In so doing, he moves the couches around. He moves the couch that Nick was killed on into a different room to block off the entryway. He goes out to buy that Krylon spray paint. He uses that to spray paint on the walls to try and hide the blood spatter. He gets the tarps from Home Depot, and he gets rope at Home Depot so that he can wrap the bodies up and drag them out to bury them in the yard. He pours paint and chemicals on the bodies to try to help with the smell. He starts digging the hole. But sometime around the afternoon of December 18th or on December 19th, he has to change the plan. He realizes that Richard is too heavy for him to get to the hole, and that he may not have the ability to get the 3 bodies from the house into the yard during the cover of night and into the hole that he has been digging. He still messes up the house, but now his plan changes to he's going to leave the bodies where they are. He's going to go back to Ohio. He's going to work out, exercise, bulk up. Remember that weight belt I told you about? And in the meantime, perhaps the bodies will get lighter as they decompose. And then the defendant will return sometime around February, complete the plan, and bury the bodies.
Whoa.
He uses Laura's phone to send messages to her family members, just like he did with Jamie. So on December 23rd of 2018, when he leaves 1954 Juanita Way, leaves the decomposing bodies of Richard, Laura, and Nick en route to Ohio. He does so to enjoy the remainder of the 3 weeks that he had bought himself for the price of violently ending 3 lives. Now, that's not all the evidence that I expect you'll hear over the next few weeks. Over the course of the next few days, Mr. Doga and I will be presenting evidence to give the general circumstances of the crime, but also to prove 4 different aggravators with respect to each of the 3 murders. 1, that the defendant has been convicted of another capital felony or violent felony. And since the defendant sits before you, having already pled guilty, he has been convicted of manslaughter for killing Jamie, which satisfies that aggravator, and also for each other murder he's been convicted of. 2, that the defendant committed the offense to avoid arrest. That in murdering Richard, the defendant was trying to avoid the arrest for killing Jamie. That in murdering Laura, the defendant was trying to avoid arrest for killing Jamie and Richard. And that in killing Nick, he was trying to avoid arrest for killing Jamie, Laura, and Richard. 3, that the way the defendant committed each murder was cold, calculated, and premeditated, based on the plan he made and the manner in which he set out to destroy the remaining members of this family. And 4, that the murder of Richard and Nicholas was especially heinous, atrocious, and cruel. And then, the conclusion of the evidence, we will ask you to weigh those aggravating factors against any mitigation that may be presented, and then find that the aggravating factors outweigh the mitigation and that this defendant should be put to death by the state of Florida. Thank you.
Thank you, Mr. Sarabia. Ms. Oliva, you may proceed with your opening statement.
Judge, I will reserve my opening statement.
All right. Thank you. State, please call your first witness.
Defense is just seeking for life in prison without parole.
State would call James Quinnland.
This guy's just like chilling in his chair, chillaxing.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do. Please wait, please, sir.
He looks familiar.
Please watch your step. Actually speaking to the microphone and loud, clear tone of voice for the court, please. Thank you.
Good afternoon, sir.
Thank you.
Ms. Stowick, you may inquire. You may.
And he looks familiar. Got a bench conference going on right here. Witness is just chilling. Yeah, this is an interesting case. We're jumping in now on the sentencing because he pled guilty. There was no trial.
Good afternoon. Could you please state your name and spell it for the record? My name is James Michael Quinnland, and it's Quinlan.
Jury will decide.
And where are you
if it faces
employed?
the death penalty.
I retired on July 4th. Where were you employed prior to that? Prior to that, I worked for the State Attorney's Office as an investigator. And
I think we saw him.
as an investigator with the State Attorney's Office, is that a position where you would be a sworn law enforcement officer? Yes, I have been. I've been a sworn law enforcement officer for 40 years this year. Back in 1985, I went to the academy, was sworn in. I have a bachelor's degree in business with a minor in finance. And prior to becoming a law enforcement officer, I was also Air Force military intelligence. What sort of training did you get to become a law enforcement officer? The basic academy training, but in my entire career, most of my career I spent as an investigator, and I've probably been to every school imaginable except for a canine school to be a canine officer. I've done all kinds of narcotic, homicide, burglary investigations, economic crime investigations, hundreds. And were you working in that capacity as an investigator when actually, let me take a step back for a second. Were you called to assist in an investigation on January, I believe it's January 2nd of 2019? January 1st. January 1st, okay. Yes, sir. So you were there 2019. So was that the first day of that investigation? For me, it was, yes, sir. How did you become involved in that? How were you called? So at that time, my role since probably 2014 with the State Attorney's Office was that I was a liaison to law enforcement for like homicide cases and grand jury cases and that kind of stuff. They actually had an investigator who was assigned to assist Tarpon Springs Police, which is a smaller police agency here in Pinellas County, and they were unable to reach him, so they called me that morning and asked me if I could assist in the case. They would probably have a need for a prosecutor and a judge for a warrant. Okay. And were you able to provide that assistance? Yes, I was. Okay. Did you go actually go out to the scene to participate? Yes, I did. I spent probably 10 or 12 hours at the scene on January 1st, 2019. And did they ask you to do anything else to assist with that investigation? That day, nothing else was done. I was only a tool utilized to facilitate a prosecutor and a judge. Okay. And after that day, I agreed to help them out, and I would go in the morning and do my work here I had to do in the morning, and then go to Tarpon Springs Police, and they had a to-do list. It was a list of leads and things they had to get done. It's a smaller agency. It's very small, police department, small CID unit. And so I would take things off that list and go do them for them in the daytime. Can you explain to the jury what a CID unit is? So CID is Central Investigations Division. It's usually people who are assigned preliminary to work on specific crimes like burglaries, homicides, rapes, narcotic investigations, and that kind of stuff. Tarpon Springs Police has a smaller CID unit than most agencies in Pinellas County, and that's why we used to provide an investigator to them who was not available the day they called for help. And did you assist in performing tasks on each of the days that you went out to the agency? I did, yes, sir, I did. Okay. Do you recall going to the agency on January 3rd? Yes, I was out there that day working. What sort of tasks did they need help with that day? So that day, it was more like when you go into their office, their CID section, there was a list of things they had to get done. I just took the next thing up on the list and that day I was asked, I chose to go show several photo packs. Okay. Now, the jury may not be familiar with what a photo pack is, so can you explain what that is and sort of how they're done? Yeah, it's a tool to use analytically to provide investigators information to maybe validate the witness's credibility. Just because you saw a crime, potentially you might not be a good witness, so to say, like you can't identify the person or details of the crime. So we use that photo pack to help narrow down and validate the veracity of the witness to make sure they really did see what they said they saw. Okay. And so you said you got 3 photo packs and went and administered them to different people? Yes, I did that day. Yes, sir, I did. Okay. Now, at that time, Did you have any idea who the suspect was?
I knew who his name was, but let me tell you a little bit about photo packs and how it's done anyways, all right? So I've done hundreds of photo packs in my life. I've been the preparer and I've been the facilitator on photo packs. And so the way it's been done probably the past 15 years at least is that the person who shows a photo pack has no idea what's inside the photo pack. And the photo pack is laid out with 5 people who resemble the suspect, potentially, but they look same characteristics, but it's actually a page put between each photograph, so it's a point in time the person's brain can be cleared. You're not going from photograph to photograph to photograph, and they might get distracted by, well, now I'm getting confused. So the photo packs were prepared by somebody else, and I agreed to go administer them, and I did so. And that photo pack, each one I showed, had 5 potential people along with the suspect.
Okay. And at that time, did you have any idea what the suspect actually looked like yourself?
I knew a little bit about it, but I wouldn't know the photo pack because when I take it out, it's a blank canvas. I take it out of the envelope, and as I bring it, I've not done the arrangement of the photographs. I don't put them in like 1, 2, 3, 4, 5, 6. That's done by somebody else, which they did that day. So my job was just to show the photo pack, the 5 people with the suspect with a cleansing page, so to say, between each photograph.
And was one of those photo packs that you administered that day administered with a woman named Debbie Laferton?
Yes, it was. Lived at 520 Cary Lane.
Okay. And was she able to make an identification with the photo pack you showed her?
Yes, she was.
Your Honor, may I approach the witness with what's been marked as States 1 for identification?
You may.
Mr. Quinnland, do you recognize that?
I recognize my handwriting in front of it. Yes, I do.
And what is that?
It's evidence. It's been opened and sealed by somebody else along the way, but this is a evidence package that you seal up your package you've done the photo pack in.
Now, you mentioned that you recognized your handwriting on the front of it?
Yes, I do. In fact, you ask them a series of questions to make sure they clearly understand how important it is not to guess. You can't say you're 80% sure that's the person or you're 70% sure. It's either you know the person or you don't know the person. And I go through and clarify that with them ahead of time to make sure that when they do pick somebody, that's the person they believe it to be. Now, of course, sometimes a person may know about the crime or the inference of the crime, but they really can't identify that person. They'll say, I can't pick him out or pick her out, whatever it might be, which is very normal. In fact, it happens more often than not.
And Mr. Quinnland, can you open that package up and take a look at that photo pack?
Yes.
Can you just flip through, just make sure that it's everything that's supposed to be there is there?
If this is what I sealed up originally, it'd be the 5 people that resemble the suspect, and then, of course, the suspect picture. And yes, the one page here that was Miss Laferton said this was the suspect that looked at the person that did the crime.
How did she mark that on that page?
She might have marked something else. What I have here is my own handwriting. This page right here.
Okay.
It was at 5:36 p.m. on January 3rd. And they're people who all resemble potential suspects.
We would stipulate to the admission of this.
All right, so it's admitted into evidence, State's Exhibit number 1, I would assume?
Yes, Your Honor.
All right, very good.
I bring it to the court.
You may.
I need walls. It's like a security blanket.
May I publish the page that the detective indicated for
Mac?
Right. Page number 4. I might also like to say is that the pages that separate that are not included in that pack today.
Okay.
The blank pages.
Did Ms. Laferton indicate what she was identifying him as doing? That identification.
She had told me that he was seen at the residence.
For the record, I'm showing page 4, front stage 1 to the jury this time. Mr. Quinlan, did you assist with any other activities with the Tarpon Springs Police Department at that time?
Trying to assist Tarpon Springs Police with a timeline. They had a large bag of mail that was retrieved from the victim's mailbox. And I agreed to go through that bag of mail and sort of like sort out what was in the bag of mail and to see what the furthest back postmark was in that mail.
Can you explain what the importance of that would be?
Well, trying to define a timeline, when potentially something was mailed and when they last checked their mailbox. And going through the mail I looked at, the oldest postmark was December 13th of 2018. Which sort of more like made Tarpon Springs Police aware of the fact that the crime happened somewhere after 2013, but before January 1st of 2019.
Just for clarification, do you mean sometime after December 13th?
That's correct, yeah, because it was postmarked that day. Usually it wouldn't come till the very next day, potentially, but right.
Thank you. I don't have any additional questions at this time, Your Honor.
Thank you. Any cross-examination?
No questions. Thank you so
All right.
much.
Thank you, sir. You may step down.
Am I excused, Your Honor?
You are.
Thank you.
State, please call your next witness.
Your Honor, at this time, the state called Deborah Laferton. She's the one that'll be on Zoom.
All right, so we're going out of order a little bit. All right, so I thought she was going fourth, but that's all right. So we'll take a break and then we'll try to set up this Zoom, because no matter what sort of preparation you do, there's always an IT issue, okay, no matter what. All right, so we'll go ahead and we'll give you a brief 10-minute break. Hopefully we'll be ready by then, okay?
He says, I'm good. I don't need a break. Sorry to bore you, Mr. Defendant. Give us a minute. We're going to skip the break because we can. Brief break for them to get Zoom set up. Hang on 1 second. All right. We're back. This is pretty wild. Just the cold, calculated, callous approach to this crime is crazy. How's that for alliteration? Lots of C's there. And he confessed. There's another C. He confessed coolly. He did plead guilty. And in Florida, because of the crime, because there's an aggravating situation, as we fix the level, thank you very much for that, as there's an aggravated factor, he is eligible for the death penalty, but that can only be determined by a jury. The jury would have to find him guilty, and he's just chatting it up with the guard. This is wild. So we have a mini trial here. The jury does not determine whether or not he is guilty. He's already confessed to being guilty. That is basically him stipulating that the facts of the case are exactly as charged. And they now just have to listen to those facts to determine if it was especially heinous, if it was, extra terrible, extra bad, if it qualifies. Here we go.
All right, you may be seated. All right, everyone's here, well, including the state and the defense and the defendant. All right, no one really asked for the rule of sequestration to be invoked, and I've been told that somebody called Court TV, who's a witness, and said, can I watch the rest of the trial on Court TV? So anyone asking for the rule to be invoked, or under the circumstances, that's not necessary?
We're not asking for the rule to be invoked.
You're not asking?
No.
Okay.
So the witnesses can watch.
Thank you. All right, so Ms. Laferton, can you hear me?
If your sound is bad, refresh and come back in.
For some reason, I can't hear you. I don't know if that's because I don't see where you have your audio turned off. I don't think you do.
Mine's on.
All right, there you go. Okay. Okay, so I turned up the volume there.
Okay, thank you.
I'm just getting so good at this. Okay, so are we ready to bring the jury back in? We are. All right. All right. I left my water in the witness room. Oh well.
I left my water in the witness room. Oh well. Can somebody get the judge's water? Ooh, Amazon just delivered. Ooh, 5 things. Ooh, that's cool. I did not order any, so that must be from my wife. This guy is disconnected from reality completely. The sole purpose of the defense here is to save this guy's life. And by that I mean get him convicted of life without parole. Get him sentenced to life without parole instead of the death penalty. Entirely the exact same thing that Brand Kohberger's defense was doing. Although they argued that he was factually innocent, their purpose and all their efforts were put towards removing the death penalty. And as soon as that was gone, he pled guilty. So, why was he sentenced separately for killing his wife? I think he admitted to that separately earlier. It's a little weird. Well, the crime happened at a different time, in a different place too. That was Ohio, right? Killed the wife 1 year earlier. He lived for a year after brutally murdering his wife, faking that she was still alive. So he got very good, just living with that. Apparently adding 3 more to the tally was a breeze.
All right. Welcome back, members of the jury.
Here we go.
State, please call your next witness.
Thank you, Your Honor. This time the state calls Debbie Laferton.
Good afternoon, ma'am.
Hello.
You may inquire. Mr. Dilley? Oh, yeah. All right, ma'am, please raise your right hand.
Swear in. Oh, yeah, tell the truth.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Very good. All right, you may inquire.
Thank you, Judge. Ma'am, can you please state your first and last name and spell it for the record?
Deborah Laferton, DeBeralaFFERTON.
Ma'am, are you currently retired?
Yes,
And how long have you been retired?
since April 18th.
This case
Of
put people into
2025.
retirement. It's terrible.
And what did you do before that?
I'm an RN, and I was working from home, from my home in Tarpon Springs at 520 Cary Lane. I was working, doing utilization review for HCA Corporation.
About how long did you do that?
7 years.
Okay. And so, did you start doing that in 2018 then?
Yes, July 2nd, 2018.
And where do you
I've
reside?
been a nurse for 45 years, but I'm sorry.
No problem. Where do you currently reside?
Currently, I'm living in Oshkosh, Wisconsin,
And how long have you lived there?
since April 27th of this year, 2025.
And where did you live before that?
520 Cary Lane, Tarpon Springs.
And did you live at that Tarpon Springs address in December 2018?
Yes, I did.
How long did you live at that address total?
It was, I moved in May of 2018, so, I don't know, 7 months. May, June, July, August.
Do you recall the people who lived on the corner near the mailboxes in your neighborhood at 1954 Juanita Way?
Yes,
How did you know them?
They had purchased the house and they had moved in, not quite sure when, I know it was 2018 probably. And she had a pair of kissing Dutch people statues, and I had asked her when she was out in her yard if I could have those, and then she said yes, and so I gave them Christmas cookies, and she and I met at the mailbox and talked briefly. So I knew them in passing.
Okay.
I'm Googling
Did you
kissing
see her
Dutch
around
statues.
the neighborhood fairly often?
Oh.
Really just going to the mailbox. She and her husband weren't much for the pool or being out and about, walking their dogs. I did see her walking the dogs.
Okay. Now, did there come a time in December of 2018 where you stopped seeing her walk the dogs?
Yes, as far as an exact date, it was just before Christmas. I know that.
Would it be fair to say that it was sometime around the middle of the month?
Yes.
Did you ever see her out and about with her grandchildren that month?
Yes, she had, I think I was told that they were 3 years old and 2 years old, and her grandchildren were visiting, and they would walk with her, walking the dogs.
Now, after the point came where you stopped seeing her out and about walking the dogs, did you ever see her out of her residence at any point after that?
No.
Did you ever see anybody else in the vicinity of the residence after you stopped seeing her?
Yes, there was a young man outside the residence on 2 occasions. I saw him and he was doing what looked like landscaping, but he was digging a trench, and it was about 3 to 4 feet deep, and at the time I saw him, it was at least 6 feet long.
That's not a trench.
Yes.
It's a grave.
I remember telling my friend in Wisconsin that there's some guy digging what appears to be a grave outside of this house, but I said, it's just odd that he's out there digging this trench.
So is that what it looked like to you then?
It looked like a grave, yeah. I mean, the dimensions, to me, look like a grave.
Had you ever seen that man in the neighborhood prior to when you saw him out digging the grave?
No.
Was anybody with him when he was digging the grave?
His children were outside with him. I was walking my dogs, and they started to run over because they wanted to pet the puppies, and I had to tell him to not have his kids approach my dogs because they weren't used to children.
Were you concerned with what might happen?
Yeah.
Now, after you saw the man a couple times in front of that residence digging the hole, did you ever see anybody else in front of that residence afterwards?
No.
Now, did there come a time that the police came out to the residence and there was quite a commotion there?
Yeah, that was January 1st of 2019.
What do you remember?
In the afternoon, they were putting up crime scene tape.
Okay. Did the police ever come speak to you about what you might have seen?
Yes, during the first couple weeks of January, there was a meeting at the clubhouse by the police, and the detectives asked if you had seen anything, no matter how small, please come forward. So I talked to the detective, and then they did send a detective to my house to take my statement.
Okay. And did you tell them what you had seen at that time?
Yes.
Did they subsequently send an investigator out named James Quinnland to show you what was called a photo pack?
Yes.
Were you able to take a look at that photo pack at that time?
Yes, he showed them to me one at a time.
And when you looked at that photo pack, did you identify the person you had seen digging that grave in front of the residence in that photo pack?
Yes.
Thank you, ma'am. I don't have any additional questions at this time.
Thank you. Any
Don't think defense is gonna
cross-examination?
cross-examine
Okay.
much at all of these witnesses. Because they've basically stipulated to the events of the crime.
Appreciate it.
Thank you.
No questions from defense. Yeah, front yard
State,
grade.
please call your next witness.
Bold move.
See if you call Donna Christie.
Christie, this is a death penalty sentencing hearing. A jury is hearing the facts of the case that has been pled guilty. The defendant pled guilty to determine if he's should be sentenced to death or life without parole. So this is Shelby Nealy. Killed his wife, and then a year later killed his family to hide the fact that he killed his wife.
Stand right here. Face the clerk, raise your right hand and receive the oath.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
This way, please, ma'am. Please watch this step. Please stand up. Now, as you speak into that microphone, loud, clear tone of voice for the court, please. All right? Thank you. Thank you, ma'am.
Good afternoon, ma'am. Mr. Doig, you may inquire. Yeah, have you sworn her in yet?
Yes.
Yes.
She was a woman. Sorry.
Okay. That's okay. Sometimes you just can't swear enough.
Good afternoon, ma'am. Could you please state your name and spell it for the record?
Donna Christie.
Could you spell it?
Pardon?
Could you spell your name for us?
Spell it?
Yes, ma'am.
G-O-D.
Her mic's turned off.
Ma'am, are you currently retired?
Yes.
How long have you been retired?
Over 20 years.
And where do you reside?
Pardon?
Where do you live, ma'am?
Target.
Target. What neighborhood?
In the Meadows. It's called the Meadows Mobile Home Park.
And is that a retirement community?
I'm sorry.
Is that a retirement community?
Say what?
A retirement community?
Yeah.
Or a 55-plus community,
Right.
I guess I should say.
Right.
Did you live in that neighborhood in December of 2018?
Yes.
How active are you in your neighborhood?
At the time I wasn't real active because I was traveling a lot.
Do you try to interact with your neighbors when you're around, though?
Yes.
And you try to keep in touch with them, speak to them, and things of that nature?
Yes.
In fact, when this case got set for trial and subpoenas went out, did you actually go check on your neighbors to see if they got subpoenas?
Yes.
So you try to keep on top of things, it seems, right? And have you always more or less been that way?
And what?
Have you always been that way, that sort of neighbor?
Well, yeah. I mean, 'cause all the neighbors around me are the ones that pretty much knew everything going on.
Do you recall the people that lived on the corner near the mailboxes at 1954 Juanita Way?
Mm-hmm. Yes.
Did you know the people that lived there?
Briefly. I don't think they've been there too long.
Can you tell us what you did know about them or how you knew them?
Well, the husband, I saw him, I never really talked to him, and the lady, I had talked to her maybe twice. So I saw her walking her dog some, but that's about all.
Okay. About how old did they seem to you?
I think he looked like he was in his 70s and she was maybe 10 years younger.
And you said you saw her out and about the neighborhood a little more than him?
Yes.
Did you ever speak with her?
Twice.
Did you speak with her at all in December of 2018?
Yeah, it was around then.
Did she say anything about what was going on in her life at the time?
No.
Okay. Now, did you ever see her around the neighborhood beyond, say, about a week before Christmas of 2018?
I don't remember, but not that I can recall.
Okay. Had you seen her walking the dogs fairly regularly before that?
Yeah, off and on. I'd see her just out from my door, you know.
Now, later in the month, did you see anybody else near the residence that you had not seen before?
Yes.
Can you tell us about that?
There was a man, and he was actually digging a trench the length of her sidewalk. He was outside digging.
Okay. How deep did it look to you?
It looked like it was getting pretty deep.
Did that strike you as unusual?
Well, yeah. I mean, don't know why he was digging it.
Did you ever speak to him or ask him what was going on?
Well, I was going to the mailbox and I waved at him and said hi, and he did the same thing. That was it.
Was anybody with the man when he was digging that trench? Now, eventually, there ended up being police out in the neighborhood to look into what had happened at 1954 Juanita Way. Were you in the neighborhood when that all happened?
No, because after the 18th, probably like maybe the 21st or so, I went out of town to my son's house for Christmas, so I wasn't there. I didn't know what had happened at all.
Did law enforcement reach out to you?
Yes.
And did you talk to them about what you had seen?
On the phone, yeah.
I don't have any additional questions this time. Thank you, ma'am.
Thank you.
No questions, thank you.
All right. Thank you, ma'am. You may step down.
Done. Thank you.
You're done.
That's 3 of the 4 witnesses we planned on hearing today. Let's see if we get the 4th one, or if we're going to be done. It is 4:30.
State, please call your next witness.
State will call Richard Ivancic.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, sir. Mr. Sorab, you may inquire.
Judge, could you please introduce yourself to the jury?
Yes, my name is Richard Ivancic Jr. Richard Lewis Ivancic Jr. It's I-V-A-N-C-I-C last name. I'm the oldest son.
All right, well,
Richard,
get there. Mr. Ivancic.
Richard Identic?
I'm 59 years old.
And you don't have to give me the exact address, but what area do you live in?
I live in West Palm Beach, Florida, the other side of the state.
And how long have you been down there?
Over 30 years.
Now, I want to ask you about some people. Did you know someone else by the name of Richard Ivancic?
Yes, my father.
Okay. And do you know his date of birth?
Yes, December 13th, 1947.
Okay, now, whereabouts were you born? What area of the country?
Cleveland, Ohio.
And what's your mother's name? First name?
Janet.
Now, your mother, Janet, was she married to your father?
She was. They were high school sweethearts.
And where did you all live when you were young?
West side of Cleveland, pretty much all over the west side of Cleveland.
Ohio people?
Ohio people. Yeah.
It's all Ohio people.
Very good Midwestern people.
And do you have any brothers with the same mother, Janet?
Yes.
Or any sisters?
My one is here today, Mark, my youngest brother. Mike is the third oldest, and then my sister Renee is here today as well. There's actually 4 of us within a matter of 6 years.
Okay.
So very close in age.
So who do you know? Laura Ivancic?
Yes.
Who is she?
I knew her.
Who is she?
My dad's second wife.
Okay. And when did she come into your life?
About a year after I graduated high school in 1985.
Okay. And obviously by then your father was divorced. And did he marry Laura?
Yes.
And while they were together, through the 80s, 90s, what area of the country could we approach?
You know,
All right, you may.
We've had to crank the audio to hear this because we can't hear. I guess his mic is turned off. But trying to hear the defendant, he's a family member, is testifying, knows people. He's talked about his dad's second wife. The defense might stipulate to all this. The defense even have experts? Wow. This is the son of Richard Ivancic, the victim. The defendant looks remarkably just nonchalant. Turn the mic off during the Zoom, didn't turn it back on. Could have been. See if they figure it out. They'll fix it by tomorrow.
You may continue.
Thank you, Judge. So, Laura and your father were living in Ohio. While they were in Ohio, were they fostering children?
Yes. Yes.
And through fostering children, did they eventually adopt 2 children?
Yes.
And do you know their names?
Jamie and Nicholas and Jamie.
So, I guess, what would that make their Nicholas and Jamie's relationship to you be?
They were ours, not by blood, but by age. They call brothers and sisters, I guess you can call to us, but they weren't by blood.
Okay.
Stop.
Now, at some point, did your father move down near you?
Yes, he did.
And was that in the few years prior to his death?
Yes, it was.
And roughly what area of the state did he move into?
He lived on the west side, or the east coast of Florida. Nearly is Lake Worth, Florida. In the mobile home there. I was waiting for Laura to come down, and I don't know if it's as expensive here as it is in West Palm, but it's a little expensive over there, so he decided to move from West Palm to this side of the state.
So when he moved down, did Laura move down with him?
No, he did not. No, she didn't, because she was taking care of her mom.
Okay. And did her mom pass in a couple of years before all this happened?
Yes. I think it was 2017, if I'm not mistaken.
Okay. Shortly before then, all this happened?
Yes.
Once Laura's mother passed, did she move down with Richard?
That was the plan, yes.
Okay. Backing up a little bit, did Nick also move to Florida and live with Richard during a period of time?
Yes, he felt it was better to join his dad because of employment opportunities.
Okay. And were you aware, did your father and Laura and Nick at some point move to 1954 Juanita Way in Tarpon Springs?
Yes, yes.
Was that roughly middle of 2018?
Roughly, yes.
Had you been to that residence ever before all this happened?
Yes, I had. I was there once or shortly after they moved in. I couldn't help them move because I travel a lot, so they had moved in and he wanted to come over and see it. I happened to be there at a cigar event, so I popped in.
Okay.
I mean, Tampa, popped in to see it. It's a nice community.
All right.
Exactly what you need.
Let me ask you this. In terms of Laura and Richard, did they keep a clean house or did they leave stuff lying around all over the place?
It's funny you ask me that. My dad is very anal retentive. Okay? He's an engineer, or he was an engineer.
He said anal retentive?
He likes things very organized.
Bingo.
Very neat, very tidy.
Okay. So would it be unusual to see receipts and things lying around the house, trash on the floor, or walls messed up?
I'm going to crank the gain just a little bit
Couches
more.
across doorways?
Very usual.
Okay. So would you talk to your father on the phone, text with him, those types of things?
Yes.
Every now and then see him?
At least every week or so, we check in. I would probably call him or text him if I was traveling to a new location because he likes cigars as well. I would share cigars with him. I'm in that business, so that's how we connected at a later age.
Okay. Do you recall his 71st birthday?
I did.
December 13th of 2018. Did you have any contact with him on that day?
I did call him. I called him on 13th to wish him happy birthday. I think it was later in the day. I think it was during the week. I think I might have been traveling before the holidays. And we were kidding or joking because he was excited that his grandkids were coming. I have two kids myself that are about the same age as his two kids. Two girls, they live out of state. And I was traveling to see them for Christmas. So we were sort of joking about that on his birthday.
Okay. And you were going to visit your children who recently had grandchildren?
Yes. It was my first and only granddaughter. It was the first Christmas, so I wanted to be there for Christmas. So.
And were you talking to your father about that because this would have been his great grandchild?
I was. And he would comment back that he was going to have his grandkids come and visit too, with Jamie and the defendant.
Now, in that discussion, did you discuss that when you got to North Carolina, South Carolina?
South Carolina.
South Carolina, that you would be communicating with him and sending him photographs and things of that nature because of the
occasion? Yeah, he loved receiving pictures, especially, like I said, I travel a lot. I send him pictures of a lot of places I go to. So he wanted to see some pictures of his great-grandchildren.
And when you would send him photographs and things like that, would he normally say something about it?
I would always say some kind of response. It could be a like on the picture, it could be something about the picture. I would always say some kind of response, yes.
So would it be unusual if you sent him photographs of the new great-grandchild and then get no response?
Very unusual, yes.
Okay. So that birthday, December 13th, 2018, was that the last time you talked or saw your father? Or had any contact with him at all?
It was.
So obviously at that point in December, you're going up to visit family, and about to be the holiday season. Were there multiple times between then and New Year's that you were sending in photographs?
Yes.
And did you get any responses after that? Did it get to the point where you were concerned?
Yes.
Did you try to call him?
I did.
And did you get any response?
None whatsoever.
Was that unusual?
Yes.
So as time goes on, is there come a point, December 31st, where you're traveling back?
It's about 10 hours from South Carolina back to West Palm. I had plenty of time on my hands to talk. So after I tried reaching out to him, no answer. I don't remember if I tried texting Laura or not. I don't remember. But I know I texted my sister, who's here, my brothers. One of them's here. And they hadn't spoken with him since his birthday either. They told me. Then I called his brother, his older brother. He's one of 6 children. So we come from a very large family. I called his brother, my uncle Ken, and we tried to start putting together a timeline. When was the last time we talked to him? And the best thing he could recollect was the 14th to 15th. And I was 13. So that was the end of that day. I got home and I went to bed and woke up the next morning and said, something's just not seeming right. Okay? I have a lot of friends in law enforcement, and I know what a welfare check is.
All right. Now, let me ask you this. So now you've compared notes. Are you concerned?
Very concerned, yes.
Now, you know what a welfare check is. Have you ever called in a welfare check before?
No, never.
Is that something that you just like, hey, I haven't talked to somebody, I think I'm going to call the police and have them check?
No, I talked to a couple of friends of mine, just to say, what can I do? Besides driving over, which is 4 or 20 miles away, could be fine. They suggested do a welfare check. I thought about it, said, that's a good idea.
Okay. So when did you place that call?
Tuesday.
So January 1st of 2019? Okay. And when you called, were you put in contact with Harvard Springs Police Department?
Yes.
And did you provide them some information and why you were calling and why they were going to end up going out to 1954 Winnie the Way?
Yes, I gave them the address, told what my concern was about the picture, not getting back from that. The officer said he would call me on the way there, and she did. When I hadn't heard anything for quite some time, I became very concerned.
Okay.
Something had happened.
Was there in having the officer go out and do the welfare check, were you hoping to hear back from the officer pretty quickly?
Yeah, it was.
And in fact, did you get upset when you hadn't heard from him in hours?
Yes.
And then did you try to get more information about why hadn't you heard?
Well, yes, I did. I didn't have any information back, so I know quite a few people in this side of the state. She called a bunch of friends and asked them to go up. One of them called me back and told me
Sustain.
So, eventually, did you get in contact with law enforcement?
I did.
And at that point, did they give you some of the information about what had happened?
Yes.
Judge Mayborn?
You may.
All right, they may be done. This is our defendant right there on the screen there. Seems to be perfectly content. It does not listen to the recounting of the crimes.
Couple questions for you.
Quite calmly.
Was Nicholas also living at 1954 when you arrested them? And there was a van there. Was that the vehicle that Nicholas generally would drive?
Yeah, it was in my dad's name, I believe, but he was driving because Laura didn't share the car. He was stolen.
Okay. Did there come a point around January 4th-ish where after law enforcement, maybe 4th, maybe 5th, after law enforcement had been in the house and done the investigation, that you had an opportunity to go in the house?
I did.
Now, and did you see the state of the house? Is that the way that your father would have, and your stepmom would have kept the house?
Something I don't
I don't have any more questions.
Thank you. Any cross-examination?
All
right. All right, Mr. Sarabia, would you like to present anything else?
Yes, Judge. Mr. Advanced would like to present the victim impact statement.
All right. Hang on a second, okay. Members of the jury, you are about to hear evidence about the impact of this murder on the family, friends, and community of Richard Ivanchik, Laura Ivanchik, and Nicholas Ivanchik. This evidence will be presented to show the victims' uniqueness as individuals and the resulting loss by the deaths of Richard Ivanchik, Laura Ivanchik, and Nicholas Ivanchik. However, you may not consider this evidence as an aggravating factor. Sir, you may proceed.
So victim impact statement in the middle of this.
Sorry to wear glasses because I'm being old. I'm here representing myself and my family. I cannot be you attendance today. I'd like to read my written statement to verbally express our feelings and discuss the impact this crime has had on me, personally, and my family. I'm speaking to you as the oldest biological son of Richard L. Sr. It was very hard to try and put into a few words a life in the family.
It's hard to hear.
My father, and a bit later with his second wife, Laura, and the journey to the foster system. So where do I start? Our mother, Jane, and father, Rich, had 4 biological children, Richard and Mike and Mark, from the first marriage. Our parents were high school sweethearts. He was an all-star high school quarterback, and our mom was the captain of the cheerleading squad at West Tech High School in Cleveland. He was quite an athlete. He had offers to play for college ball, that is, until they had me. During his senior year in high school in 1965 and 1966. They were raising 4 kids by the age of 24 and were married for 14 years. But, of course, as they were childhood sweethearts, known each other since 7th grade, so just about over 20 years. After the divorce, my father spent some time searching for what he wanted to do with his life. Since graduating high school, Dad had worked his way up the ladder to CEI, which is Cleveland Electrical Committee, and retired as a draftsman in their engineering department. After meeting his second wife, Laura, they decided to start their family. Unfortunately, after having 4 kids, due to the previous medical procedure, my father was unable to see additional children at this point in his life. This led them to the path of foster parenting. Dad and Laura were foster parents for many years to many children when they lived in North Rockland, Ohio. While they fostered many kids from various broken homes and families, these biological kids all lived in different states. We tried to keep in touch with them, get texts, phone calls, occasional visits to town to celebrate a holiday or birthday. Dad and Laura moved to Columbus, Ohio, after he retired, where he started a business called Powerline Accessories with a partner of his. They were what you call a modern-day storm chasers that would send power crews to areas impacted by major disasters, like hurricanes that we had in Florida. In fact, many of us in the courtroom might have been impacted by our father's work to restore power during some of the recent hurricanes during the 2007-17 timeframe. In 2017, he sold his shares of Powerline Accessories. During this time, Powerline. He enjoyed boys' trips with his brothers, Ken, John, and Bob, along with some close friends. And on occasion, he would invite the young guys. We would join him, including myself, my cousin Jimmy, or brother-in-law, Doug. We would have a great time bonding with boys, playing golf, visiting local horse tracks or casinos, just simply enjoying life. It wasn't until they met and cared for Nick and Jamie that they decided that these were the 2 kids they wanted to adopt and raise as their own. Nick and Jamie were very young. I believe around the age of 5 and 8. I could be wrong. Both Nick and Jamie came from very challenging and unstable families. Laura and my dad changed all of that. They quickly became the children that they could not have themselves. They gave them everything they could possibly want or need growing up. Yes, they were quite spoiled. Even after retiring, they took care of Laura's parents in in the later years, as well as coming from refugee during this time. My dad and Lori loved foster kids that they cared for and were torn every time they had to give them up. They were innocent and loving parents and grandparents that had many more years in front of them. In fact, I was driving back from visiting my kids and granddaughter in South Carolina. I shared pictures of a trip with Dad and Laura, but never would have guessed that this was the last time I talked to them. We will never get to see them again and can only hold on to the memories that we shared along the journey of life before they were all taken away by him. Thank you.
Anything else regarding this witness? Any cross-examination? Thank you, sir. You may step down.
Thank you. We've got the end of the audio, but that should be our last witness for the day. Let's see if there's any more. Does state have any further witnesses? And they said, may we approach? Maybe he has one job. The bailiff is bouncing. He's like, let me do it, let me do it, let me do it. Let me lock him up. Judge was standing. Nope, that was somebody else. It's a sidebar. Audio's been muted for this. But apparently we can film their mouths. Judge appears to be looking at a clock, talking about scheduling. We've really opened the iris on this camera. Kim, thank you very much for
the witnesses that we're going to have today. So we're going to stop for the day a little bit early, which not bad news. It's obviously been a long day. I do have a motion calendar in the morning with various other cases on the motion calendar. However, Judge Susan St. John has graciously volunteered to handle that for me.
Thank you, Susan.
So she'll be handling that while we can start early. We really want to make sure that we get this done.
I guess
Done even a little bit early. So if you can
Let's
be
just play
back
with the
tomorrow
volume
at
controls during the
2:45, so we'll have a full day of evidence and testimony tomorrow. I believe that I can tell you where to meet. It'll be in.
I don't know why we're playing with the volume during the live stream.
Anything about the case, you already know all of that. Everyone has a juror badge. Don't forget to have your juror badge on in the morning. If it was me, if I brought it in the house, I would probably forget it, so I might want to leave it in the car, or if you have a purse, keep it in your purse so you don't forget it, and then have it on as you come in, because when people see that you have that on, that tells everyone not to say anything to you that they shouldn't say, or say anything about the case or anything like that. All right, anybody have any questions or anything? So we'll be done by 5 tomorrow. If we can stop a little bit early, that'll be great, since we're going to start fairly early. So and we'll see you back here at 8:45, okay? Thank you.
All right, so as they go back to the to their logo and everyone leaves for the day, we are going to be back tomorrow to hear the rest of this. I guess we're going to hear both testimony as to the facts of the case, as well as witness statements intermingled in, victim impact statements intermingled in, which is going to be interesting. This is day one of a triple murder sentencing. The part that's different about this, though, the defendant has already pled guilty. He's like, I did it. It was me. And he's confessed. That part is not in question. Somebody's calling me. Hang on.
Call from. To accept, press 1.
Hello, this is...
Hey.
Who's this?
This is Debbie Cook.
Hey, Debbie, you have to say your name when you call. That's the whole point of the screener.
I didn't hear the thing ask me for my name.
Okay.
I didn't hear it this time.
I saw you in chat again, Debbie. It's good to see you. How are you doing?
I was just calling to see if the number still worked.
It does. It does. We have not yet burned this burner phone. So far, so good. We are, man, what a crazy case. This multiple killer. He confessed. This trial, there is a jury, but the jury, the only thing they're going to decide is he's going to get life without parole or death penalty. The state obviously pushing for the death penalty. The defense is pushing for life without parole. And so
what is the defense doing? Like, they're not cross-examining anybody. What is the defense?
They're going to present their own stuff to say why he should not be killed, why he should not be death penalty eligible. And that's,
so they're not going to do anything during the state's case in chief. They're going to wait.
Not if it has to do with the elements of the case. Nope. They're like, yep, those are the facts. We've admitted to that. We've pled guilty. That's already been determined.
Okay.
So it's a little different that way, and it will be pretty quick. We're only going to hear cross-examination when it approaches those elements the defense is going to present, maybe if it has to do with his mental capacity or something like that they might be arguing to the jury later to say this is why you should spare his life. That's the only time they're going to be cross-examining any witness on this. But they'll have experts.
Are they claiming like mental stuff or
I don't know yet.
What?
There are some crazy documents in this one. Amber is tearing into the documents, and they say they are insane. So we'll have to see where they go. This is going to be fairly quick as far as trials go. I've heard
Amber, where can I find these documents?
Discord. You can find them on Discord. Crochet so thank you for the super chat. Super chat cat.
On which Discord? Is that the Gavel Drop still around?
Yeah.
It is?
Oh,
okay.
Yeah. Yes.
Okay.
There's a link to it if you need it there
Cool.
in chat.
So. Okay, cool.
Debbie,
right,
it's good to have you here.
Awesome.
Good to see you.
Yeah, great to
All
be
right.
back for a little while anyways. I'm so busy now.
I know.
You
It's
didn't
awesome.
tell me this was work, Scott.
It's work. Did I lead you to believe that this is just easy and it just happens by itself?
Yes, you did.
Well, mission accomplished. So, it
Bye,
is
guys.
work.
I miss you all.
We'll see you, Debbie.
Love you.
Bye.
Bye.
All right. Crochet so sends a super chat. Cat, thank you for that super sticker. Appreciate that. Bug Dugger member for 26 months as an attorney. Thank you, Bug Dugger, for your massive support of the channel from myself and from others in my family. Thank you. Just looking here as he gets let out of the courtroom. Just smiling, talking with the bailiffs. Hey, how's it going? We got the same haircut. We're twins. He's like, I'm not your twin. Yeah, so out he goes. Yeah, wild little case here. Tomorrow, this is what we got going on tomorrow. Obviously, we've got this case that's going to continue with the sentencing hearing and the evidence that's going to be presented there. We also have a Brian Kohberger. It's another similar situation, pled guilty to murder. We've got a Brian Kohberger hearing, but this one has to do with the gag order. And we are hoping, fingers crossed, that the judge is going to address the issue of the sealed documents. I don't see any reason right now for him to maintain the seal on those documents now that the plea has been accepted. It can't go back. It's a done deal. So Idaho 4, coming up tomorrow. I'll have to check to see the time. We'll probably interrupt. We might run it on Top Mark Media and then interrupt this stream to follow that and then come back to this and finish up for the day. So it might be a long day tomorrow, which is Thursday, by the way, which is podcast day. So we have a very long day. Yeah, there's an Idaho 4 book out. It came out before any of the documents were unsealed, so we'll have to see when the documents come out if they actually match up with the facts of the case. But Idaho doesn't like to unseal. Well, there's a lot of people pushing for it, and some of those people have powerful lawyers. So we'll see if they will do it. Let's see. He said 8:45. So what time are you starting? Before they do. So it looks like we might be doing an early 8:30 start tomorrow, which would be great. Weapon of choice, hammer for all deaths? Yes. Pretty gross. Pretty gross. Let's see. All right. That being said, that will wrap it up for today. It is 5 o'clock, nearly straight up here, so it's time to go home. I am home, but it's time to go out and say hi to the family. See if I can start working on the air conditioner. I think we're going to run a new drain line out the other side of the house, down through the eave, down the side of the house. See if that'll help. It'll be good. We didn't get to do that. It's fun. It's good to be back in my box in the corner. Thank you all for being here. Hope you guys had a wonderful, wonderful day. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe and go live again tomorrow morning around 8:30. Yes, the pool in the attic is still full. It's you can come over and swim in the attic if you want. Just don't splash because then it ruins the walls. We'll be back in the morning, bright and early. A lot of fun. It's going to be a wild one, so buckle up. And then, of course, podcast tomorrow as well. So I'll send my maintenance guy to help. Our maintenance guy offered $650 to run this line. We said, no, thank you. I can buy the PVC myself. I can probably do it for less than $100. That's the route we're going. So we'll see how it happens. You guys have a good one. We'll see you tomorrow. Bye-bye.
There's nothing in the order that restrains you from talking to cats.
Thank you.